Registry Matters is an independent production. The opinions and ideas here are that of the hosts and do not reflect the opinions of any other organization. If you have a problem with these thoughts, FYP. Recording live from FYP Studios, East and West, transmitting across the internet. This is episode 141 of Registry Matters. Are we at your age yet, Larry? Seems like we should be.
Getting close. You got another 30 episodes to go.
Okay, so you're in the 170 range? Okay, I got it.
Yep. So it's not long now.
We should not beat around the bush at all because there is a treasure trove of content. We got a decision to talk about. We got voicemails. We got a new segment we're introducing. We got all kinds of crap going on. And also, I think this is the third week in a row, we have a Patreon extra piece. Some people say they like it, Larry.
I'm amazed. What are we going to be doing in the extra today?
The extra is going to talk about the, let's use this term again, defunding the post office?
Defunding the post office.
Yes. So a quick little teaser. There's been has anybody talked about the post office to any level of seriousness, ever, other than when stamps go up, everyone loses their hair catches on fire when they say stamps are going to go up by a penny or something like that. But given the current state of things, that they're the post office is all of a sudden all over the news. So we're going to have a little 10 or 20 minute chat about that.
Now, just out of curiosity, what does that have to do with people, with PFRs, people forced to register? What does the post office have to do with that?
Let's see here. Well, you would receive your registration notification by mail. That would be one thing. But as far as we've been doing these extras and they are at best 2 or 3 degrees tangentially removed from the registry. Maybe we're sort of teasing a second podcast idea. Maybe.
That's kind of what we're doing. People who want to know, we're actually giving some political insight into issues that go a little bit beyond those forced to register. But they do tie together indirectly because politics in general, philosophical beliefs tend to translate to policies that may not be beneficial to the post office as well. The same people who believe in harshness on the registry that also believe in defunding the post office, those things may run together. But anyway, we'll get into that in that segment. If you haven't become a patron yet and you want to hear something juicy like the post office, better sign up.
That is, I mean, you set it up and you walked right into it. So I'm glad you did that. I was going to say, and how do people get these Patreon extra episodes, Larry?
They become a supporter of Registry Matters at $1 a month, or at the various levels up to $1,200 a month,
or higher, Larry. It doesn't have to be a maximum of 1,200. It could be higher. It could be 12,000, 12 million.
Do you have?
We got a full house in chat too, by the way.
Do you have a box that says indeterminate amount monthly? I didn't know that.
You could sign up at the $1 that level, and you can change the dollar figure to be whatever you want.
I see. All right. Well, that's how you do it. Patreon.com/Registry Matters. Sign up as little as $1, and you'll get early distribution. Usually Sunday, and you'll be provided the extra content that we've been working on.
All righty. Well, then let's dive right on in. Oh, wait, I need to start that over. Was this late breaking, over the top awesome news that we got to cover tonight?
Well, it's late breaking because it happened within 2 days of recording. And since we record weekly, we consider anything within a day or two to be late breaking. We're not like the Fox or the CNN News Channel where we're on all the time. So this is late breaking. There is a long awaited decision regarding registration in the state of Colorado. And it's been pending for years. The appeal's been pending since 2017, and the decision was finally announced on Thursday. And we're going to go into a fairly deep dive later in the podcast. But it did not go favorably for us, and it was very disappointing. And we had put a lot of effort into it. NARSL had put a lot of effort into it, and even the ACLU undertook the appeal after the case was originally decided at the lower court. So that's going to be a good unpacking coming up shortly.
And like you said, so it's great news for our people, and they're going to be super excited dancing in the streets. But no, maybe not. Maybe not quite like that, right?
I don't think we're going to have a lot of dancing on this one.
Alrighty. So I think my show notes are off. Did you want to go right into the conversation with Justin from Tennessee, or are we going to cover that later?
Let's go ahead and do that now.
Cool.
Justin is a great patron, great supporter, and a really nice guy. And he had put in a request a little over a week ago, and I had to punt last week because I hadn't gotten in touch with him. And at that level of support, he's entitled to a conversation. And I decided that I better call him last night before this episode. And he brought up something that I thought would be helpful to others. And those are the type of questions we really like, because if you just have your unique problem that doesn't affect anybody, there's no podcast in the world that can unpack individual problems. But if you have a generalized issue like he raised, I thought, well, gee, that would be good. Do you mind if I talk about that on the podcast? And he said no. So he had been thinking about what state to move to, which we don't encourage state shopping. That's something that people do on their own volition. But he has been thinking about states, and he came up with the possibility that he might want to leave Tennessee, where registration is pretty harsh. Plus, there's, I think, a $200 annual fee, and he thought he might want to go to Vermont. And he said, but I would be screwed under Vermont law. And I said, why? And he said, because Tennessee's got me as sexually violent. I said, well, really? I said, did you go through an adjudicatory process where you determined? He said, my conviction was out of the military. And I said, well, that's nice. But what my question is, have you gone through a process where you've gone through either an administrative tribunal, or have you gone through a court process where they have rendered that title to you of being a sexually violent predator? He said, no. And I said, well, that's what Vermont is talking about. That's what they're referring to when they apply different rules to people that have been adjudged to be a sexually violent predator. And I said, so you are instilling fear into yourself that you don't need to have in terms of that component of Vermont's registry, because it won't apply to you. They simply, because Tennessee declares everything to be sexually violent as far as a categorical approach, that doesn't magically make you a sexually violent predator under the process of being declared a sexually violent predator, which is usually done by a court proceeding, but sometimes by an administrative one. But there's a process to do that. So I put in the show notes the appropriate statute out of Vermont where we can actually send that to him. But it goes through the process of how the determination is made, what the burden of proof is. So, Justin, if you're still thinking about going to Vermont, this would not be the impediment if you have not been found and declared to be a sexually violent predator under some process where you were a participant and you were able to offer rebuttal evidence, and there was a conclusion at the end of that process that you were an innocent.
Larry?
I'm here, waiting on you.
Oh, okay. I heard like a loud Windows bong noise, and I wasn't sure if you evaporated off the planet.
I was trying to figure out how to kill that after I heard it, but yes, that's what to Justin. He doesn't have that particular fear. Now, there's been no analysis done of anything beyond that, because I told him we would work on figuring out if either of the two decisions that we've talked about recently in Tennessee would offer him any hope of relief. The Roush decision, which we talked about some time back, and then the Reed decision, which we talked about last week. But in terms of his fear, that fear is an unfounded one.
And so that'll be in the show notes if you're looking for it, Justin. It'll come out midnight on Tuesday, unless, of course, I pressed the wrong button and released stuff early. Right, Larry?
Yeah, midnight Monday is usually when it comes out. And this past episode got out Sunday night, because you were traveling and you got confused.
Yeah, I pressed the wrong date. Stupid hotel room. But yeah, so you can find it in the show notes on the website, not on the YouTube. YouTube came out early by accident. The crazy date thing. Look, just to clarify, I released it at 23:59. So I released it at 11:59 on Monday night. So it comes out effectively, it's there on Tuesday. And I picked but the YouTube thing is at 12 a.m. So the date is different for that perspective. Anyway, it's just what I've been doing for a year and a half. And anyway, it's confusing. Anywho, are we going to move on now?
I think we can move on. This is a video, audio, whatever it is that I put in from KFOX 14 in El Paso, Texas.
And I will have to find the video.
I can set it up while you're finding what this is a story out of Fox 14 in San Antonio, where the police are insisting on frightening people about, because of the protests around the country, that there's been a precipitous plunge in interest in being police officers. And it was a very, very poorly done story that I'm going to pontificate about after we play the story. But I think after we play the story, it'll make more sense to people about what was wrong with the story when they hear it. Then I'll go into that. But yeah, this is something that ran on Fox 14 just recently.
All right, here we go.
Fewer people are trying to become El Paso police officers. It's an issue that's affecting police departments across the country.
KFOX 14 News at 5's Holly Bach joins us live from West El Paso to show us what our local police department is doing now to attract new recruits. Holly?
Well, on average, the El Paso Police Department receives about 5,000 applications per class, but their numbers for their most current class, that number of applications is actually cut in half.
Why they're down? Police is just not a profession that people are seeking. It's being demonized in the media. It's being demonized throughout the country.
The number of applications of people wanting to be a police officer in El Paso is down from the department's normal average of about 5,000 applicants.
Policing throughout the country is under a lot of scrutiny right now. And I think it could play on a person's decision-making to try to come into this profession.
Numbers in the El Paso Police Department's current class show only 2,619 applications received. 677 passed the written exam, and 441 passed the job simulation. PD began the academy process with 34 recruits and is projecting to graduate 30 police officers in October.
Being understaffed in any capacity doesn't just affect response times, because we're constantly having to adjust to make sure that we're responding to the calls for service.
Right now, the police department has 1,253 employees, and there are 80 vacancies. Sergeant Robert Gomez says as of 2 weeks ago, nearly 50 people have quit or retired.
In talking with Chief Allen, and this has come up before, and Chief is adamant that we're not going to lower our standards just to get bodies.
After recent protests calling on police brutality following the death of George Floyd, Sergeant Gomez says it's hard to tell if this will impact the numbers for their next class.
Police officer right now is definitely difficult. These things swing like a pendulum. Police are in the positive light, and something occurs and police become negative light.
Now, right now, their current academy class is actually the first one of the year. They had their second one planned for July of this year, but it was canceled due to COVID-19 concerns. Now, Sergeant Gomez tells me that they're really not planning on having another academy class until 2021, but that is still under the works. For now, reporting live here in West El Paso, Holly Bach, KFOX 14 News at 5.
Well, how about that, Larry?
Yeah, I actually heard that on KKOB talk show here. We don't receive TV from the El Paso market, and then I went and found it because they were talking about how that had so severely restricted applications, suppressed would be a better word, the applicant flow to the police department. And I thought, gee, with just basic reporting, they took everything the police said at face value. Now, first of all, let's look at the numbers. They normally have 5,000 applicants per a class of 35 to 40, which doesn't exactly sound like that there's not an interest in being police officers. Then it dropped. Now, we are in a pandemic where people are not applying for jobs that require close contact. I think if you were to look at the jobs, unless they're really low-skilled jobs where people are forced to work because of economic circumstances, but if you look at jobs where people have options, applications would probably be down in most of those jobs. That would have been a good question for the Fox reporter to ask as well. How does the application that you are down by 50%, but in similar jobs where there's a lot of personal contact, when you're in a police academy, you're training together, you live in a dorm most of the academies, and you're wrestling around and you're doing macing one another and you're doing tasing one another, you're doing all these things. So but the raw numbers were down to 2,619 or whatever they said. and then 677 passed test number 1, and then another 400 and something passed test number 2, the simulation. The written test was that you're smart enough to write a report, read, understand the basic English language, and so forth and so on. Do you have the mental ability to be a police officer? They still have quite a selection pool for a class of 30, and then when they go through the simulation training, which testing is what you might do in situations that would kill you. A lot of people get dropped because they're not fast enough on the gun. They still ended up with more than 400 for a class that's going to be of something in the 30 range.
But what about all the people that have retired and left the force, Larry? We need these people on the street to keep us safe.
Well, we're going to get to that. But so they had 400 something to pick from for a class of 30, which doesn't really sound all that challenging to me. I've never had that luxury of picking for 400 for 30, but according to them, that presents some challenge. But if it presents such a challenge, it might be time, rather than describing it as lowering the standards, it might be a time to rewrite the standards to be more reflective of the community. And I've said it before on the podcast, I want to see more women on the police departments across the country. I believe that if you look at the totality of police violence, you see so little of it inflicted by women. You see so few shootings. I mean, we did have the one, I believe it was in Dallas, where the officer thought that it was her apartment, as I remember, and then she shot the guy because she told him to freeze. You remember that one?
Mm-hmm.
But that's an anomaly for a female officer. Women generally can de-escalate things. They provide a soothing rather than the aggressive macho. I would like to see that. So maybe we should look at revamping the physical standards. The women are never going to be able to match the men on upper body strength. You wouldn't be able to expect a woman to do that on average. There would be the rare one, as you're going to tell me, that she's stronger than a guy, and I get that. But on average, but maybe we need to look at maybe raising the age limits. Maybe we ought to look at having officers that are just a little bit heavier. In particular, I know in my part of the country, they're very rigid on.
Man, they're heavy as hell here.
Yeah,
they are not fit and trim here.
I thought about that when I said it. I said, remember when I'm in Georgia, you run into these officers that they can barely waddle around.
Yes, they live at Dunkin' Donuts.
But here they're very big on fitness and physical agility. Maybe they could relax that a little bit, and maybe they could let people that smoked a little bit of dope. Maybe they could just be more reflective of the diversity of America. But particularly more women. I'd like to see that more women chiefs, more women writing policies, and more women officers on the front lines, particularly in volatile situations. But this story was so poorly done because let's take a look at the question you just asked about the retirement. Police officers generally get to retire in 20 or 25 years. Well, let's just take the 25 because since I don't know El Paso law. If you take 1,250 and divide it by 25 years, you're going to have a natural retirement attrition of 50 officers a year. Mm-hmm. So you've got to have 1.5 classes to keep up with retirement. So since they're not doing but one class this year, and they don't even know if they're going to be doing a class next year because of the pandemic, it stands to reason that their ranks will shrink unless they do lateral hires, which I mean by hiring from other agencies and poaching and attracting them with better salaries and benefits. But you're going to have a shrinking El Paso Police Department anyway.
But wait, doesn't that help with the budget? Don't we want a smaller government?
Well, we do, except for the things that people that say they believe in smaller government support, which is usually law enforcement, prisons, and military. Then they want larger governments there.
I couldn't resist.
But the bias of the story was the point I was making. Just some basic fundamental reporting could have raised these things. That if I can think of this, and I'm not a reporter, I'm hopeful that someone who's gone to journalism school and is a reporter, if they can think of that, surely they could ask those questions. So my question is, does Fox want to be unfair with how they report something? Do they not want legitimate questions asked? Did Fox have an agenda here when they ran this? It sure sounded like they did to me.
Yeah, and I realize that this is like a local story, but there's that whole Sinclair media outlet where they have overlaid over on top of each other like 20 different media outlets, and they're all like script by script. It's identical, saying the exact same story. I realize that that's a local market program, but
so that was my whole point. I think that this was very poorly reported, And it was journalism at its worst, and it scares people. People that saw this in El Paso think that they're going to be pillaged and plundered because of the anti-police movement, and that people are not wanting to become police officers because of this. And nothing could be further from the truth. They still have plenty of people to pick from in their most recent class, by their own statistics that I'm assuming are accurate.
All right. I think we can move on to an article from KSL.com. It says Utah Supreme Court says children don't have to testify against abusers ahead of trial. Is this an Eighth Amendment thingamabobber, Larry?
No. Well, you will eventually get to confront your accuser if probable cause is established. And I was talking about how probable cause is a very low threshold showing. And oftentimes attorneys waive it because it's a perfunctory conclusion. In Arkansas, it's established because the prosecutor says there's probable cause. That's really about all there is to it. But in our state, you have the right to have a grand jury or a preliminary hearing where a court determines there's probable cause. But in order for this to be a bad decision, they would have to extinguish your right to confront your accuser at court, and they haven't done that. They have said that at the early stage of the proceeding, that the person, the alleged victim, does not have to come forward. Now, remember, the state has to at least make that threshold showing of probable cause, and it would behoove them to call that witness if they needed to make that threshold showing to keep the case moving. Because if probable cause is not established, the charge would be extinguished, and that would be the end of it. So the state will put on their witnesses enough sufficiently to establish probable cause. So I don't see this as a significant. It was a unanimous ruling, and I don't see this as very significant. Now, those out there who say I've always sided with the victims, this is a major victory for the victims' advocates. But I don't think this does significant damage, or if any damage at all, to the process. So I'm not going to bash the victims' advocates this week.
This week, but your days are numbered. It's coming.
well, as I've said, it's a policy thing, and this turns out to be a creeping reach. If they come back, which they generally do, they're never satisfied with what they get. If they come back and want to extinguish the person's confrontation rights at trial, then I'm going to have a whole different reaction. But right now, I'm not overly concerned. But they do. There's one thing about victims advocates you can count on: they never feel like they have enough. And you can watch that with whatever they do. I've been in the state nearly 40 years, and we brought the drunk driving rate down dramatically. And their answer to it when the rate declines is to lower the BAC, the blood alcohol content, so that we'll have more people in the dragnet, because they say arrests are down. And I say, well, isn't that what we were striving for? Well, yes, but there's still more people doing it. So they brought it down from 10 to 0.08, from 0.10 to 0.08. Which has become pretty much the national standard. But now they want to bring it down even lower because we've still had fewer and fewer people being arrested. And I would think that would be a good thing, right?
Definitely.
But not to them, it isn't. They want to still continue to have the same number of people arrested. And it's a solution in search of a problem.
Okay. Well, let's keep rolling, and we will take up an article from KSL.com. Again, it says, keep our children safe. Local police track down sex offenders. This was, they're looking for people that are not in compliance. Larry, there are only 8,000 registrants, PFRs, in the Utah. And they found a very small number of them. They said 20% of the peoples. So I guess is that 1,000? No, that's not 1,000 of the 8,000. So they looked at 1,000 people, and they found 33 people now face pending charges. They were looking for people that were living where they weren't supposed to. They were just looking for like technical or their special condition violations. Why do the people have to go out and look for our people, like trying to make a living and make things work?
Well, I'll say that this will annoy some people because they have the money from the federal government to do it. This is a funded thing by the federal government since the AWA passed in 2006. There has been funds available shortly thereafter to do address verifications. One of the arguments made in the AWA for the AWA in Congress was that there were 100,000 missing sex offenders. And I have never contested that number because I don't know what the number really was. And I do know that people had decided to exempt themselves by moving across state lines. But this was the solution. Congressional testimony. One of the supporters, and I don't remember if it was in the House or the Senate, but I remember I was watching the hearings, and he said, "We do a better job tracking library books than we do sex offenders." So this is what the reason why this happens is because local law enforcement, state law enforcement, the people who believe in small federal government, they want the federal funding so they can go do this, and they collect a big amount of money to meet the federal criteria of what constitutes a residency check. So that's, you want to know why it happens? Because there's money to make it happen. That's why.
So it says, this is one of the people, I guess, like one of the officers, it says, this is a big deal. An operation like this sends a message to the PFRs that law enforcement is watching. And if you don't register and don't pay attention to the law, we'll come get you. More scare tactics. But legit ones too, I should say.
Yes, that's what it gets down to is money. The old adage of follow the money, and this is what they're doing, is following the money.
All right, then. I have no idea what Red Lake News is, but this is from Red Lake News, and it says, contractor loses deal after VA discover he's a PFR. He had his crime from some 13 years ago, and he has just like a janitorial contract. He secured $700,000 in federal contracts, provide cleaning services at a VA hospital, and they did some background check and found that he's one of our people, and they said, never mind.
Well, so much for competitive bidding.
Will says that USA Today dug that up. Okay, so that's what that person was. I remember hearing that particular situation. I didn't realize it was this one.
But yeah, but so much for competitive bidding. Apparently this, under the competitive bidding process, was the best contract, but we can't have that. And you know what they'll do? We talked about it in pre-show. What they'll do is they'll change the application process. They'll say, because they had modified the application to have a look-back period that was relatively short comparatively. But what they'll do is they'll leave the look-back period the same for other offenses, but they'll say the look-back period for a sexual offense is longer. Have you ever been? So they'll make it, have you ever been convicted of a sexual offense, or have you been convicted of any other felony within the last whatever years? That's what they're going to do. That'll be their fix.
And I just have to bring this up as being obligatory. Like, we have to, could the person have a louder muffler drive-by? But so we want people to pay their debt to society and come out, and we want them to be upstanding citizens and live in a cardboard box under the bridge?
I've not figured that out, Andy. I've really I've been troubled by my inability to comprehend. My analysis is so flawed, apparently, but I want people, when they come out after we've spent a bunch of money on them, I don't want us spending all that money, so I don't want as many people going in, and I don't want them staying as long. But when they finally do come out, I want them working and paying taxes, because they're people who have their hands out for all the services that government provides. And I don't want those people to be one of those who, with a hand out, I want them to be handing stuff in so that people that have the hands out can collect. And I've struggled to figure out where I'm going wrong here. I want you paying taxes after you've been in prison.
Have you ever heard the argument? Have you ever heard someone say that I'm a better than average driver, and the majority of people say that they're a better than average driver?
I've heard that, yes.
And so if everyone is a better than average driver, then that would move the average up to be, well, that would be what the average is. So if more people are on the bottom end of the average of whether they earn enough to contribute to the system versus like earning over what they would, there's some sort of median income where you are either like a person that takes from the system versus like Bill Gates earns way more and he contributes more to the system than he's ever going to get out of it. So we would want more people above the average putting in than on the bottom end taking out of it.
Well, let's just bring it down, but way beyond Bill Gates. Let's bring it down. The minimum wage is so low, the federal level is $7.25 an hour. So if you do $7.25, and we didn't do this in show prep, times 40, and then you do that times 52, you've got an annual salary of $15,000. Let's just take Social Security, which is widely popular with everybody. Everybody has their paw out when they turn retirement age wanting their cut. But in order for you to get paid, someone has to pay in. There has to be a collection of revenue, of inflow to the system, because what you paid in is paying for the people that are collecting now. So that $15,000 at current Social Security taxation rates generates a tax of $1,153. And then the employer matches that. So that's roughly $2,300 a year. That doesn't pay for one beneficiary. Now, I would much prefer you, I don't know that fuzzy math, but I would much prefer you be making $90,000 a year, because if you make $90,000 a year and you pay 7.65%, look at the difference. 90,000. I put in too many zeros. Times 7.65%. You're going to put in $6,885 multiplied by the employer match. So all of a sudden, you've put enough money in to almost support one beneficiary. Now, which is better for society? The $2,200 or the $6,800 times 2, which would be, might as well call it $14,000. We're better off with you putting in $14,000 into the system that everybody widely supports, and they have their hand out for their cut. We all benefit more if you earn more. I don't understand why people want folks failing and not earning money. I can't get that.
And just to double back around, I'm assuming that with a $700,000 contract, that this dude would then potentially hire 5-ish something employees, maybe 6 or 7, maybe 10 employees, and then throw in the chemicals and all that stuff that they need in equipment. So, like, I mean, this guy is like, quote unquote, like creating jobs for people, right?
That would be the argument that conservatives would generally make, is that it's a job creator, an entrepreneur, and they would want that. I'd like to hear from Lindsey Graham. What does he feel about this? He was actually moderately on, not as strong as I'd like for him to be, but he was in moderate support of the First Step Act and made some very positive comments. I'd like to know what Lindsey thinks. So anybody out there that has in South Carolina has his phone number, text him and find out what he thinks about this contract being terminated, and if he would register resentment on the Senate floor about it.
We'll reach out to him as the podcast and see what he says.
Well, when he knows we've got thousands and thousands of listeners in his state, he's liable to respond to us.
It's very possible. All right, let's I think we're here at the feature. I think
we are. So we're going back to what is the nickname for Colorado? I live there and I forgot what they are. What is the state of Colorado?
The Mile High. I have no idea, dude. I don't know any of these. This is just not my forte to know what the slogan of a state is. Well, but so this is something that we covered some time ago. I don't remember. I don't know if I was helping produce the calls at the time, but so I do remember the Narsal in action with the what's the lady's name?
Alison Ruttenberg.
Alison Ruttenberg. I remember she was super duper nice.
Alison Ruttenberg.
Yep. She was great on the phone. She answered 8,000 people's questions on the phone call. Everyone was super excited about this decision. It sounded like she did to me, it sounded like she did an incredible job. But me being the layperson, I think anybody that does this work does an incredible job. And some interesting things. Well, anyway, so Judge Mach, he ruled in our favor. And so here is the decision. So this was something from like 2017 that this went down, and then we've just gotten this decision a couple days ago, 2 days ago.
That is correct. That it's indicative of how long these cases drag on and how expensive they can be. And Alison, I think, was on maybe twice. I know for sure once, but we did have her on what used to be regular calls. And they've become very infrequent now because we do the podcast, and then the pandemic has directed our attention and energy elsewhere. But yes, we had her on, and she was a great guest, and she did do a good job, a very good job, with the resources she had. Remember, she stated on the call she didn't have any resources. You remember that? She said, "I'm broke. Didn't have any money."
I do remember that, and she got maybe even she specifically selected people that were indigent.
Yeah, I'm not remembering that, but I remember that she didn't have any money for experts, and she was elated that Judge Mach did not want any experts.
Right, that it wasn't a required piece, and she thought that it was okay to go about it without having spending $5,000-$10,000 for an expert to come in, and Mach was okay with all that.
Well, yeah, he didn't want it. He flat out just didn't want experts, and he wanted to hear from the. Now, Judge Richard Mach has now deceased, has been for I think almost 2 years, and he was a Nixon appointee. For those who didn't sit on that call, he was a Nixon appointee, and at the time he did that. My assessment of him was that he really didn't care about all the appeal. He wanted to do the right thing from an emotional standpoint, and he did what he thought was right. But unfortunately, when you're declaring a statute unconstitutional, right isn't enough. You have to have law on your side, and we're going to get into that when we go through this decision. But he did do the right thing, but the right thing was not supported by the law.
And you provided me with something of a cheat sheet that I have no intentions on reading on the air. Is there anything that, so then there's also some questions that we can bat around. Is there anything before we start hitting questions that you want to highlight from the cheat sheet?
No, I think we can go straight to questions because the what I've cut and pasted from the decision is going to be converted to a blog that we're going to hopefully get out tomorrow or Monday on the NARSL website. So that this is basically an advanced preparation for that, and then for you to refer back to as you're doing the questions that I would like to be asked, and then there's questions that you have probably dropped in here as well.
Yes. So this was filed in district court, which I right off the bat have no understanding. This wasn't anyway. What is district court like to begin on with?
Well, district court is in this particular case is referring to a United States district court, and I don't know the precise number of district courts, but that's what is a trial level court for federal issues, for federal criminal, federal civil issues. And it's a court of general jurisdiction for federal claims. And within the federal system, there are other courts also. You also have the magistrate court, the magistrate judge, and you have the bankruptcy court. But this is a general subject matter jurisdiction, and this was a United States district judge. Every state in the country has U.S. district judges. So that's what this was in. Now, Colorado itself and New Mexico, most of the states have something that resembles, every state has a court of general subject matter jurisdiction. Some call them different, like in Georgia, it'd be a superior court. Colorado, I think it's a district court. Michigan, I believe they refer to them as circuit courts. Arkansas, circuit courts. We have district courts. So you have state district courts also. But in this case, it's a federal district court.
Why? So for the clarification, why didn't they file it just in the state court of Colorado? Because these are just state court peoples.
Well, that's a good question, and those are strategic decisions that are made when you're evaluating making a case. Attorneys have this crazy notion they like to get paid, and in federal court, there's an easier route to compensation as a prevailing party under Section 1983, 42 U.S. Code 1983. So that's one consideration, but it's not the only consideration. You have additional considerations that you're looking at how the case law is. So if you were going to look at making this claim in Colorado State Court, you'd look at how the state court has ruled on registration, and you might look at it and conclude that the door is closed based on a binding precedent from the state Supreme Court. And you might look at the federal court as around the different circuits, the case law is evolving, and you might conclude that the type of claim you're going to make would have more of a chance in federal court. And then you also have the consideration of federal judges are insulated from the public in terms of the political ramifications of their decision. They do live in the communities, they do have kids, but they do not have to worry about reelection. And that gives them an additional, under Article 3, they're appointed for life, and that gives them additional insulation you don't have a Persky. There's nothing they can do. If Mach was still alive, there wouldn't have been anything they could have done to him.
And this is my own question, where do you think if he were still alive that would have changed this outcome at all?
It could have. I don't think so. It's a long shot. The 3-judge panel was unanimous, and the way it could have changed it is that some judges through their service develop an enormous amount of respect, and when they go up on appeal, if they draw the right panel where there's a respect level for that judge, they start with how do we affirm this judge because they respect the work that they've done. Well, when a person's deceased, there's two ways to look at it. You could respect their work by affirming them, or you could say, well, gee, he's not going to know it if I flip his decision. And so it could have, but I think that being that it was a unanimous panel, that probably didn't play much, if at all, in their thinking.
All right. Is there anything specific about the individual challengers that would be important as to how the challenge went about? So the individuals were David Mallard, Eugene Knight, and Arturo Vega?
That's correct. And I don't remember all the specifics of their individual circumstances. I think one was convicted as a juvenile, and that's all I particularly remember. I think that might have been Vega that was convicted. His crime occurred as a juvenile.
Correct. I believe you're right. And then, so this took place in the 10th Circuit as well. And how is that specific? There are 12 circuits in the country. Is it 13? I always get that number. It's either 11 plus DC or 12 plus DC.
It's 11 plus DC. And the 11th is actually the newest. That's where you are. I don't think we've created, I'm certain we haven't created a circuit after the 11th. The 11th was a split off. The 5th used to, if you went way back, years ago, back to the 70s, if you had an appeal out of Georgia, it would go to New Orleans to the 5th Circuit, and they carved out that circuit when Jimmy Carter was president and made the 11th Circuit, and then you have the D.C. Circuit. So Colorado is geographically is in the 10th, and that's a very large, these western circuits are very large. I think the 10th may be the largest geographically, but the 9th is the largest in terms of population that it serves.
Oh, okay. So 10th just in geography. So, but California's in the 9th, so that obviously has the most people. And that does that cover just the left coast?
It covers the left coast, and I think Alaska and Hawaii are in there, if I remember right. But yeah, it's the most populous, and the effort through the years have been to try to break that circuit up because it traditionally has been more liberal, and that has begun to change because of the presidents that named the judges. Just like the district court judges are appointed for life by the president, the Court of Appeals judges are appointed for life by the president, and the Supreme Court justices are appointed for life by the president. And when you elect a president, you're impacting who's going to serve on these courts for a lifetime. And the younger the nominees are, the longer they're going to be there. And then right now, there's been an accelerated effort to confirm as many as they possibly can, because there's a chance that in this election we may have a different president. So in the case of this administration, they kept the Republicans control the Senate, which is the confirming apparatus. They kept the lid on Obama in the final couple of years of his presidency, and they held up confirmations. And then they started with a backlog, both at the circuit and district court level. And of course, they also started with the Supreme Court vacancy that they'd held for almost a year. But then they did an accelerated confirmation. They've been on full blast, and even during the pandemic, rather than looking at the HEROES Act passed by the House, they were busy rushing more judicial confirmations through. So that when you vote in November, if you like the type of decisions that you're getting, keep voting the way you've been voting, because that's what you're going to get more of.
A podcast that I used to listen to, at the time he had predicted that it would be like 45% of the judicial nominees would be filled by like half of the total in the 4 years would be appointed by Trump.
I don't think
some ridiculously large number. Well, at the time it was only like 30%, but that was a year ago that was done, and they're still pushing them through like hot and heavy.
They are doing that, but I don't think it'll be that high. Now, if he were to serve 8 years, he would certainly that would be a realistic number. But in the case of the election, people need to take this seriously. Who's appointed to these courts and what their judicial philosophy is has a lot of impact on where we come out on these decisions, and so take it seriously when you vote.
Now, I know that the judges themselves are nonpartisan, and they go by the law and they do their interpretation. But the reality is that they do have their own biases of this issue, that issue. Where would you call the 10th Circuit to land as far as more liberal, more conservative?
I've not been really following the circuits as closely as I should have, but they've all taken a very rightward leaning in recent years. Now, I think Robin did the analysis, and he said it was one Democrat of the 3-judge panel. There was one Democratic appointed and 2 Republican appointments, and the Democratic appointee voted the same way.
Yeah, I was going to say it was unanimous.
I don't want to inject politics into this at this point because I didn't see it in the decision. I really didn't.
How different is this from the case we discussed last week from Tennessee?
Oh, it's a hugely different than what we talked. First of all, that was a district court decision that was out of Tennessee. That would be the Reed decision. But Tennessee has a much more restrictive registry than what Colorado has. So you weren't doing the same comparison in Tennessee. And Tennessee has the wind to their sails because they have Does versus Snyder out of the Sixth Circuit, which is binding there. The Does versus Snyder case is not binding in the 10th. It's only persuasive
Does Snyder is Michigan?
That's the Michigan decision. And that is in no way binding. And it wasn't really all that persuasive because what Michigan requires, Colorado doesn't. The restrictions Michigan imposed, Colorado does not.
Can we dig into that for a minute? Of like something in there in the reading of the decision was that they didn't word it this way, but the way that I'm taking is that they don't have, for example, residency restrictions in Colorado. Did I catch that correctly?
That is correct. They don't.
Okay. So to me, one of the biggest disabilities and restraints that the PFRs would have is where you can plop your head every night. Also, that would then follow that where you can or can't work. And if Colorado doesn't have that, and they're trying to make the claim that this impairs their ability to get a job, but that would then move over to the private sector going, well, we don't want this kind of person working there. That's not the government giving you the disability or restraint.
That is correct. That's what the court found.
But if you went to a Michigan state or a Tennessee or a Georgia state where those things are in place, that is the government saying that you can't do these things, that would give you some sort of ground to stand on saying that this is some kind of disability or restraint.
Yes, that is a very fine analysis. And that's what when people get argumentative with me, which they frequently do, they say, well, you must be some kind of dork. You don't understand that nobody will hire me. And I say, that is correct. I understand that. I understand that completely. And I say, but where does it say, if we're asking that a law be stricken as unconstitutional, where in that law does it say you're forbidden to work there? Well, Larry, it doesn't say that. I said, okay, well, then we can't hold the law as responsible for that. The company chose not to hire you. And you do believe in the rights of companies to choose who they hire and fire. I mean, you don't want all that old government intervention, do you? and then, of course, they do want government intervention on this, but the companies are making the decision, as the court pointed out, to not hire or to hire. But it's not a Colorado restriction. You can work wherever you want to in Colorado, as far as the registry is concerned.
I understand.
Ready to be a part of Registry Matters? Get links at registrymatters.co. If you need to be all discreet about it, contact them by email, registrymatterscast@gmail.com. You can call or text a ransom message to 747-227-4477. Want to support Registry Matters on a monthly basis? Head to patreon.com/Registry Matters. Not ready to become a patron? Give a 5-star review at Apple Podcasts or Stitcher. Or tell your buddies at your treatment class about the podcast. We want to send out a big heartfelt support for those on the registry. Keep fighting. Without you, we can't succeed. You make it possible.
Okay, but then what would be interesting, should they then appeal this case, is the next step for them to go to SCOTUS?
That would not be the next step initially. You would file for a reconsideration, which on a unanimous decision, it's hard to imagine that you could, if you didn't convince one of three, it seems a stretch that you would be able to convince two of three. I mean, just looking at simple arithmetic.
I'm with you. But if they, so you said they would file for some kind of review. Where would that be?
Well, you would ask the panel to reconsider.
Okay.
But I'm saying that realistically, the panel is not going to reconsider, because if you were not able to convince one of the three of that panel to start with, it seems a far stretch that you would be so persuasive on reconsideration that you would convince two of three.
I see.
So that means reconsideration probably is doomed. But that you need to do that. You need to file that if that's what you want to do. But it's not going to work. Then you would ask for a full court review, a hearing en banc.
Oh, okay. So then you'd ask the whole judiciary panel up there on the 10th to look it over.
You would ask them, and that is seldom granted. as well.
Okay.
We talked about it in the Flynn case where it was granted by the D.C. Circuit, but that's seldom granted. And it's particularly unlikely that they would grant it when there was no dissenting opinion. Again, if you didn't convince one person on a 3-judge panel, that's one of the arguments you would make for en banc review or for reconsideration was that if you look at this stinging dissent, I mean, Judge so-and-so, I mean, all of a sudden that becomes your hero in your argument for reconsideration or for en banc review. And you hang that up there and say, this is really important, and this judge got it right. Well, you don't have that here. So when you file that motion, those 2 motions are likely to die and being denied.
See.
And then you would be able to file a petition for the U.S. Supreme Court, which would be very unwise to do as well. But and before you get to the reason why it'd be unwise, they're going to get some many thousands of requests to grant cert, and they would then have to have 4 of the Supreme Court justices say that they would like to hear this particular case. So out of I think it's something like 9,000 or some number like that. And then they only hear 1% of those. They only hear something like 90, 100 cases a year. And you would need 4 of those judges to agree to hear it. And what would be the damage if the Supreme Court did hear it and then confirmed the reversal of the decision? It would be devastating. It would set us back a generation if they did that. And that's what they would likely do in this particular case, because this registry is not nearly as punitive as what Michigan's was. Now, they declined review on that one. They declined review on Pennsylvania. Our best hope would be they decline review on this one as well. But if they were to grant review on this one, what the state attorneys general would argue, they would argue that you would, if a petition were to be filed, the state's not going to file a petition because they won. So that you would not want to risk your victory. So the state is as happy as a lark. And the Attorney General of Oklahoma, which led the group of AGs from the circuit, has already pontificated about what a wonderful decision it is. But if the losing party were to file a cert petition, you would probably have amicus briefs come in from around from other AGs around the country. They would say, "Oh yes, you definitely want to hear this," because they would want to have another bite at the apple to overturn Smith versus not Smith, but those versus Snyder. Because they would say there's a circuit split here because we've got this here in Michigan, and you Supreme Court, you're the only one that can settle this circuit split because we've got one circuit saying that it's not punitive when we got one saying it is, and please step in. And this would not be the case you would want them to step in on, because there's a case in Alabama that would be in the 11th Circuit, the McGuire case, which the 11th hasn't decided yet. That's the case you'd want the Supreme Court to see because Alabama's registry is so debilitating. That's the one you want the cert petition to go to your Supreme Court on. You do not want this one to go there.
You brought up the Oklahoma dude, and it says, today's ruling is a major victory for public safety advocates. Attorney General Hunter said, sex offenders are violent and, statistically speaking, some of the most likely to reoffend. Online sex offender registries allow the public to know who among them is a child predator or who has been convicted of rape. To hide this information in order to make individuals convicted of these crimes feel more comfortable is utterly irresponsible. Anyone advocating for this position should talk to victims and survivors of these types of crimes who will forever remain scarred by these horrific acts to find out why the registry systems are important. I think that he has the victims' advocates giving him money.
So, there's a litany of more questions before we run out of time. But
absolutely.
But the headers were binding precedent that the 10th Circuit is bound by precedent that's already been established in the 10th Circuit regarding registration. And then there's the argument that they made it was banishment, and of course the Supreme Court, the 10th Circuit soundly rejected the argument because it's not banishment. And that's a question.
Because the government isn't banishing. Yeah. So the government doesn't say that you can't live here, but the owner of the apartment complex or the whatever, they say you can't live here, and that's not the government banishing you. It's like I do want to say that it's kind of splitting hairs because the government is pushing out the information that you are this, and I'm not saying that information is not factual. They're certainly creating some kind of bias. If it were race related, Larry, if they were like, hey, we're publishing information that this person is black, well, I'm not renting to black people. Like, okay, I know that we're not a protected class, but we're like, to me, it's just splitting hairs.
I don't think so. The banishment by I mean, our listeners are largely textualists, or so they profess to be. This banishment is when if you look at what banishment meant in colonial times, and we don't believe in that liberal mumbo jumbo of evolving standards of decency. Banishment is when you're told to leave town and not come back. The Colorado Sex Offender Registration Act does not tell you to leave town. It does not tell you not to come back. You are not banished from living anyplace. You're not banished from town at all. And that if you're a textualist, which a lot of our listeners are, you would be applauding this because it is not banishment as the framers of the Constitution understood that word to mean at the time. And we've played this clip over and over again about textualism and how it's to be interpreted as the words, what they would have meant at that time. Banishment is unconstitutional, but this is not banishment as banishment was understood in colonial times. And so magically now we've got people who believe in that liberal mumbo jumbo of evolving standards of decency.
I've referred back to this before. Paul Dubling did a presentation, I forget which conference it was, and he put a map up on the projector screen there, and there were just bubbles drawn all over the place. Like you couldn't go to the state capitol to go redress your grievances with the government because there was a daycare. Maybe it was in the capitol, but maybe it was like nearby at a shopping mall. But you couldn't go there because of the bubble drawn. And you zoom out far enough, and the whole map is just covered by all these red bubbles. Yes, they haven't banished you. They haven't said you can't live here, but they said you can't live here, which effectively means you can't live kind of sort of anywhere except for that tiny little space under that bridge. Like it's banishment by a different means or different set of words.
Well, first of all, that wasn't an issue in this case. There were some restrictions in Colorado, but again, banishment as the framers understood banishment to mean at the time did not mean what you're trying to evolve it to mean now. It meant that you were told to leave town and not come back. If you are a textualist who believes that we should interpret based on how the words would have been defined and what they would have meant at the time, you cannot evolve that to include what you're trying to do. That is not textualism, because it's not banishment as the framers understood that word at the time. Now, do you all of a sudden believe in evolving what words meant that were written that long ago?
I personally ascribe to the idea that things probably do evolve. Maybe not very rapidly, but I'm inclined to believe that what they wrote in 17 and change has something different of a meaning today in 2020.
Okay, so you're not a textualist.
So if you say that you have the right to, well, I mean, like, I'm trying to see how we could twist the wording of you have the right to confront your accuser. Like, I don't see how those words can be twisted, but the right to bear arms, I think, carries some differences based on what they knew then about weapons versus what they know now. Same thing, like, you don't have an absolute right to freedom of speech. You don't have an absolute right to bear arms. So, like, the word banishment of 200 and change years ago would mean something, because what was the population in 17 and change? Like, there were probably like 1 million or something people in the United States. Like, it would not be hard to go find somewhere else to live. And you could just go move on to some land somewhere, and now you go make your foods and whatnot. But we need people very rarely live off the land. They don't homestead in today's world. They live in a society where you need grocery stores and gas stations and jobs, and like if there are churches nearby and you can't live near them. And I know that this isn't the case of this, but like, you know, it's banishment by a different set of words or terms or just definitions.
Well, but again, that I'm just illustrating. People who believe they're textualists, you may not actually believe what you think you are, because this is a textual interpretation of what banishment is and what it isn't. There's no banishment here by the textbook, by what a textualist would be what the words meant at that time, and they did not mean what we're trying to twist them to mean today.
All right, let's move over to you are Mr. Due Process. There was something in here about due process claim, and it also was struck down, shut down. What was that about?
Well, I'm not an expert on due process, so I
didn't say you're an expert. It's just one of your favorite things, though. You are all about some due process.
I am, but the case law didn't support that. So I just cut straight from the opinion that the Supreme Court has held what due process to protect fundamental rights and liberties, and it cited the Supreme Court decision Washington versus Glucksberg. And then they said in the decision, this is their words, not mine, the appellees failed to show how CSORA, Colorado SORTA, violated their fundamental rights. They cite no case holding that compliance with sex offender registration law implicates a deeply rooted fundamental right. Rather, all courts that have considered the issue have concluded otherwise. So it may, in people's opinion, you may be entitled to due process, but the courts don't agree with you. They see that there's no due process here for people in the registry. They say your due process occurred when you were convicted. That's where's your due process.
I don't know what their due process claim was, though. What did they think that was being violated? Like, were they saying that due process rights when they go to Home Depot to get the job and Home Depot says you can't have the job, like that was the violation?
I haven't read the original complaint in a long time, but I think it had more to do with getting off the registry. There was a process that does exist, okay. But I'm not sure on that. So that's why I just chose to go straight from what the court said, that they had failed to do.
Sure.
The court was very harsh on them, and I'm glad that I've got the language from the court, because I don't want to criticize Alison at all, but the court made it clear that this case sunk because there was a failure to distinguish themselves from binding precedent. That's what the court said in here, and that's not me saying that. That's the court saying that. The three-judge panel said there was a failure for them to distinguish. And in fact, I highlighted that paragraph. The panel emphasized that the Supreme Court precedent and our governing case law compel us to reject the district court decision upon de novo review, which means a brand new analysis of the application of the Mendoza-Martinez factors. We conclude that appellees have not presented the clearest of proof punitive effect, and therefore CSORA is not punitive as applied to appellees. Accordingly, the Eighth Amendment does not bar application in this case. That's on page 16 and 17 of the opinion.
Okay. Let's talk about that disabilities and restraints piece. So the panel found that CSORA, and that's the Colorado Sex Offender Registration Act, I assume?
Yes.
Right? All right. Yes. So it did not impose any disabilities and restraints. It looked like the person at Home Depot, he didn't get fired from his job, but they moved him to another place where they wouldn't allow him to work or something like that. I thought that's how I read it.
So, well, maybe they did.
So he lost his job in effect of it, but not like it wasn't the government that said, hey, we're going to move you over here to this different place. Oh, damn, that's within 1,000-foot restriction zone.
Well, except there are
that wasn't the case.
Zones.
No, I know. So that wasn't the case, but so that would be so if there aren't those kind of things, so now your information is published on a website, which certainly is a disability and restraint on its own, then what are the disabilities and restraints that they were claiming?
Well, again, I don't remember the specific complaint, but disabilities or restraint, the way you win these cases is when you have clear-cut disabilities or restraints, where you're not allowed to live places, you're not allowed to work places, you're not allowed to be present in places. You have significant impairments in your daily life. And the Colorado Registry does not impose that. There's, I think, residency restrictions in Inglewood, and I don't know if those have been struck down or if they're still operating. But as far as the state registry, there are no restrictions in terms of where you can live, what you can do. So the disabilities where cases have gone well have been because they were clearly disabilities or restraints, things you have to do. The only thing that they made somewhat of a showing was that you have to report into the registration office on a periodic basis, but they did not find that to be sufficient as far as disabling, because you only have to do it once a year in most cases in Colorado, and they didn't find that to be enough.
It's a big state, man. You might have to drive really far to get to your office.
Well, it depends on. I think they do it through the sheriffs in Colorado, so you would have to go to the county seat or where the sheriff's office would be if that's the way they actually do it.
Okay.
I think it's registry.
All right. Well, this is like a total crap decision, Larry, and I know that I know particularly Will is deeply upset because they ruled against us. Even though one thing that I want to really strongly emphasize is, to me, yes, we should all be sad that this happened. But it happened, and you can like rationalize and logically work your way around where we could improve in the future. So I don't want to just say, well, damn, it sucks. We should have had the ruling in our favor just because it should be in our favor. But like you're describing it that they made, like, I think you're saying they made the proper decision. Might not be the quote unquote like the humane right decision, but they analyzed it correctly, I think.
Well, try not to be quite that strong because legal minds can disagree. What I'm telling you is that what they decided is legally defensible,
right? To
come up with that conclusion. If you're not an activist court, and let's just back up. In a democracy such as we have, when we allow people to impose their own rules on themselves through the elected, who they elect, and through self-governance, for a black robe to come in and say, I don't like what you've done, I'm going to disallow what you've done, is the strongest of all medicines. And I wish I'd have found the judge, Richard Koff from Nebraska, when he actually succinctly put that in his decision when he found Nebraska registration to be constitutional. He said, simply me liking it and me wearing a black robe doesn't entitle me to nullify the people's work. You're talking about exceptionally strong medicine when you say all you people out there collectively with the folks you elected have made a mistake, and I don't like it. And that's not how we set this country up to govern. We set it up for people to be able to decide how to govern themselves and to impose things on themselves. And bad policy doesn't magically become unconstitutional. Because you don't like something, that doesn't magically make it unconstitutional. And registration in and of itself, just the mere act of registering someone, whether it be on a sex offender registry, whether it be on a young men's draft registry, whether it be for the children of Flint that have been exposed to lead water, whether it be any type of registry, whether it be a voter registration registry, registries do not necessarily inflict any punishment or any disabilities or restraints. So registries are not inherently unconstitutional. You could register sex offenders constitutionally if you chose to.
Yeah, and we have a pretty thorough example of that an episode or two back. Will is asking the question, it says, did the court weigh the fact that the publication of the registry allows vigilantes to use the registry as a hit list to carry out murder? And also, he was telling me that one of the plaintiffs also had some sort of website where they were extorting his information, like, hey, here's your information. They were doxing him, I guess, and if he paid them X dollars, they would take the information down. And what I wrote to him, and please correct me if I'm wrong, is that I don't think that they were in a position to introduce new arguments. If Alison didn't bring it up, then they weren't going to introduce it on their own.
Well, you're correct. And at the appellate level, you don't get to introduce new evidence that wasn't reviewed below. Appellate courts are not reviewing evidence. They're not reviewing taking evidence. They're reviewing the evidence that was introduced, and they're determining it based on the law. So you don't get to bring new evidence in on appellate review, and that's what really confuses people. They think that oral arguments is a hearing to put in new evidence. It is not.
And do you think that would the public misuse argument help win cases?
I think it could. I think that as the impact of the internet becomes more apparent, it has become so prevalent, I think that is a cause of action. I do not believe it was a part of this case necessarily, but I don't know for sure. It'd be a good thing to have. If Alison, she's probably very, very, very sad.
Yeah, sure.
Trying to figure out what to do next and what the right course of action is. But it'd be a good thing to have her come on and talk more about what the strategy was at the time and those particular claims, why they were put forth the way they were. But everybody on the registry, you may not have the same claims. You just because you're on the registry, there may be multiple versions of things that in New Mexico, depending on when you finished your sentence, paid your debt to society. the disabilities are considerably less and the requirements are considerably less.
Sure.
It may be so your cause of action may be different based on your individual facts, and she didn't pick what the particular facts were of those individuals. They were what they were. So I don't really know enough about it, but I think what we can learn about this, and that's when you're trying to strike down a law as being unconstitutional, you never just think about the district court. You may think you've got the district judge in your pocket, and you may think they get it, and they may very well get it. Mach did get it. But you have to realize that the state is not going to stand idly by and say, oh, well, if Judge Mach said so, well, of course that makes it all right. They're going to appeal. And you have to think about where this case is going to be when it's at appellate level review. What is going to go wrong? And I said at the time that this case was very weakly supported on evidence. There just wasn't enough of it at the time of the punitive effects, and certainly not cruel and unusual punishment. That is an almost impossible standard to meet when you talk about something being cruel and unusual punishment. Let's talk about the cruel and unusual punishment. We put people in all sorts of capital punishment situations. I think the electric chair might still be in use, and if it's not, so states who couldn't buy the potion have resorted to alternate means of execution and alternate drug concoctions. And the Supreme Court has said over and over again, we've played Scalia saying it, that the death penalty is not cruel, nor is it unusual. And it's amused me that people, if they can put you to sleep permanently using very painful and very, savage means, if they can do that to you, and that isn't cruel and unusual, it's hard for me to imagine that a cruel and unusual finding would be upheld on appellate review by simply having to report into a registration office periodically. That doesn't seem nearly as cruel as having an electrode put on your head and having thousands of volts of electricity put through your body and you dying.
It sounds to me like more of your liberal standards changing decency mumbo jumbo stuff.
Well, but the it's difficult to meet the cruel and unusual punishment. That is when I saw that finding at the time, I said, wow, we've had very few findings around the country that the registries in themselves inflict punishment, much less the next level of that punishment being cruel and unusual. And that made that decision very vulnerable to begin with, because it was a long reach to say it's cruel and unusual, in particular with very thin evidence underneath, with no experts. If you're going to claim that the registry causes people not to be able to find housing, that nobody rents to them, where's your evidence? This is not one of those things where judicial notice can be taken, which judicial notice is when something is so accepted as to be a fact of life that you can ask the court to take judicial notice, and the court can do that, and then you don't have to prove out a point. But we don't have the proof that we can ask the judge to say, Judge, you are to ask for judicial notice that simply the person being on the registry, that all landlords deny them and they accept other felons. You're going to have evidence that other felons get through, because if I'm the state, I'm going to argue, well, it's the felony record. This apartment complex, I look at their application and it says, have you been convicted of any felony? Just so happens that offense is a felony. So therefore, he got denied because he's a felon, not because he's on the sex offense registry. Now, you and I know that that's not the case. We know that people get denied simply because they're on the registry, and other felons would get through. But you have to prove it.
There. Let me throw this at you, Charles, in chat, just slightly off topic, but related. He says that up in New Jersey, there was a judge's son who was killed a few weeks ago by a vigilante. Now the judge is calling for judges' addresses and personal information to not be available to the public online. It's an identical situation, just obviously like the judge isn't a convicted felon of any sort and all that, but it's the same thing, just sort of inverted over. So if we could make the logical step that, oh my God, these public officials, maybe we should keep their information private, then wouldn't that go to say that PFR's information should, at a minimum, be Leo only?
How would we be able to? Narsel has written about that, and we published it. But being that the visual impairment, he wouldn't have been able necessarily to read that. But we just released. Was it yesterday, or the day before? We just wrote something about that, and we did a comparison about what the judge and sex offenders have in common. And so, is there a way that can be provided to Charles where he can hear what we wrote?
I have no idea how to answer that one.
I'm sure is there anything that converts text to talk? Because that's
sure.
What we
he's got all kinds. He's got all kinds of applications that do that. He even has a service where he can. Be My Eyes, maybe.
I'll provide the article from the NARFLA website, and he can convert it. But yes, there's some argument there, and there was a little a disagreement. I wouldn't call it a significant disagreement, but there was discussion even before we released that about adverse impact and consequences of people criticize us for saying that. But we did draw a comparison that here we have an innocent. The judge's son was killed. The husband was seriously wounded, and it's easier to find a person on most state sex offender registries than as a federal judge. You have to go through a lot more work to find out where they live.
I bet you they go into it knowing that their information would be restricted to some degree.
Well, you do everything you can to not make it obvious where you live, and they have security precautions at the courthouses for judges. But that was an innocent family that has suffered a serious criminal behavior. Yeah, it was. But we've had the same thing with people on the registry where family members have been in the crossfire, and South Carolina comes to mind, and even others. And if we value human life, then even though nobody cares about the person forced to register, what about the innocent people that are harmed by these public registries? That was the point we tried to make in the blog, is that if you care about people that are innocent being harmed, well, my goodness, what about the hundreds of thousands of people who have their address that are subject to all sorts of retaliation, their family members and harassment, and the victims, how they're being victimized? That doesn't seem to bother anybody.
Yeah, the ostracization of a kid at a school, etc.
The family didn't do anything wrong. I mean, if you want to look at it intellectually honest, there's a very close comparison in my mind.
I agree. Anything else? We've been doing this one for, 45 minutes?
Yeah, I think we've beat this dead horse, and it's time to start wrapping up anyway.
Yes, it is. We can move right over to that. We got 2 new patrons this week, Larry. I think that's pretty much all thanks to you. So we got a Bradley and a Brian, and Brian came in at a much more generous level. And so thank you very much to both of you. Mucho, 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 mucho.
And in fact, it gives me a chance to pontificate. Brian's level is supporting someone who wants us to provide a transcript to. And he said he didn't have anybody that came to mind, but he said if you receive an indigent request, fill it. And we have, and we will. We've already received a number of indigent requests saying, the transcripts, I found them to be fabulous, but I can't afford it. And those of you that are reading the transcripts in prison, we realize that $10 a month is expensive. That's why there's the option of having a patron supporter on the outside that has greater access to funds, or consider pooling your resources within. The transcript would probably be good for more than one person. I don't think it's going to disintegrate after one reads it. So pool your resources and have 4 of you go in together, or whatever number, and subscribe. We're not going to know how many people are reading it. The more the better, as far as we're concerned. So that's another way to do it.
Absolutely. I would like everybody in every dorm in every institution to read about it. Let's play a voicemail message from one of our original patrons, Larry. This is from Jeff. It will play eventually. Why can't I hear it? Oh, I turned the volume down. I got to start this over then. Of course I didn't have it set right, Larry. Why can't you hire the right kind of help?
Can't find them.
Good evening, Larry and Andy. I hope you are both doing very well. I don't have a question tonight. I actually had a comment. Oh, and by the way, this is Jeff from Kentucky, Captain Crazy on Twitter. But anyway, a girl posted a picture of a guy's mugshot with a link to his sex crime on Facebook and said where he worked and urged people not to shop there because of him. I was afraid she may cuss me out and call me a pedophile sympathizer, but I reluctantly sent her a message on Facebook and explained to her that the guy may have kids that he's trying to support, and he probably has bills he needs to pay. And if we take away everything in his life that is positive, he is more likely to reoffend. And by the end of the conversation, she was anti-registry. We talked a lot, but that was the gist of it. But the point of this message is, guys, you can't be afraid to talk to people about this. I know it's frightening, but no one's going to do it for us. And yes, this girl that I talked to was not a lawmaker, but she was a member of the public, and that's whose opinion we have to change. And I guarantee you, she will talk to other people about what I said to her, and maybe more minds will change because I messaged her. But anyway, that's all I wanted to tell you guys. And as always, FYP. Take care. Goodbye.
Thank you for that, Jeff. Really appreciate it. That was I like that message a lot.
What a fabulous way to end a podcast. I mean, that is really indicative of what we're trying to get people to do, as one-on-one education. And that's just such a positive outcome to have someone completely turn around in the course of a conversation. I mean, fantastic, Jeff.
Like I think you brought it up that someone said, what does FYP stand for? Do you want to go over that again?
Friendly young people.
Oh, no, that's Will's interpretation of it. So here's the scenario, Larry. I am I'm a local shoe salesman. Or let's see, I'm a Fuller Brush. Is that the right? I'm a Fuller Brush salesman, and I come to your door and I go, good afternoon. I would demand to know who lives in this house. And I'm at your front door. And I have stuck my foot in the door. I'm not going to let you close it. And I say, I demand to know who lives here. What is your response?
Well, it would not be very kind because I don't think you have any right to know who lives in the house. And I would say something that starts with F and ends with a K.
Frank?
Well, I don't think we can say it on the family oriented program, but I would say the whole thing is you have no right to know. And the PFRs have acquiesced and said, yes, every time they're asked that question, you have a right to know. And the answer, rather than they have the right to know, the answer is no, they don't. And FYP.
And there's a podcast that I listen to that's very funny, and it's a science fiction one, and they would use the word juck. So you could probably figure it out from there. Which letter do you want to use? I forgot which one you said we were going to use. We have an email question, a mail question from someone in prison. This is a new segment that we're going to do.
It's the one from Rigsby, and we don't have time for both, so we'll just do the Rigsby question. And do you want me to read it, or do you want to read it?
I got it. So it says, I'm an inmate at the Illinois DOC who currently has approximately 11 years left to do. I am a former resident of NM, New Mexico, a graduate of New Mexico State University, and both my sons were born in New Mexico, and they both still live there. Though the years, I don't understand what that says. I'm curious as to the situation for sex offenders there. First, does the state of New Mexico accept interstate compacts if I wanted to parole MSR there? What is MSR?
Mandatory supervised release in Illinois.
All right. Secondly, are there presence residency restrictions? Thirdly, I work in the wastewater treatment. Could I still be certified in New Mexico with a felony or PFR offense? Finally, I see internet-based selling as maybe the only way to make it with the way employers will be looking at me. Does New Mexico restrict internet use? I just want to live and work and be a productive citizen. Again, do you think I can do well in New Mexico? Thank you in advance for all whatever help you can provide. Sincerely.
This segment is coming about through our outreach to prisons now. And at NARSL, we get a ton of letters for the legal corner. It started out slow, and then through the years it's built, and we just select one a month, 2 per issue, generally speaking. And this is going to provide us an outlet to answer more questions, because I hate to throw away good questions, but if I can answer something that would, again, apply to more than just the person, and he's got a lot of good questions buried in here. He says, though years away is what he means there. I'm curious. So he's planning in advance. So his release is years away. And so his first question, does the state of New Mexico accept interstate compacts? Yes, all states do. Absolutely. You can apply to come to this state when you get within a zone of release. You can make that application in prison in Illinois. our state will do everything they can to deny your interstate compact request. And it doesn't matter if you're in Illinois or whatever state you're in. They're going to find, if they have to measure or invent something in terms of finding a way to deny you. Now, the second question, are there presence restrictions? No, not imposed by the registration. But while you're under supervision, the Corrections Department does have residence and presence restrictions, and they will be imposed on you. And that's how they deny a lot of the people. They will say that your proposed residence is within 997 feet, and it's 1,000 they're looking for, and they'll figure out a way to measure it because their specificity is vague. They don't say if it's from structure to structure or from property line to property line, but they'll come back after the 45 days to investigate it. They'll wait till the 44th day, and they will send back to Illinois and say that it doesn't qualify, and they deny that. So even though we don't have any residence restrictions imposed by the registry, supervising authorities will impose those restrictions, and they will do everything they can to keep you from coming here. And then in terms of the last question, I do not know the answer to that. We don't have any restrictions as far as the registry imposes on where you can work. You can work anywhere that'll hire you. But the Corrections Department may decide that your job is inappropriate. They may not feel like they can supervise you adequately. You may have too much freedom. You may be doing door-to-door sales. You may be doing something that they say, gee, that job's not appropriate. And then on the final one about internet-based selling, they're going to do everything they can, particularly if they can come up with a shred of evidence in your file to severely restrict your access to the internet. Again, it's not the registry, it's the supervising authorities that will do that. And if you want to be self-employed, which again, that generally would be a good thing because if you're paying taxes, that's beneficial to society. But they will tell you to go out and find a regular job, which you can't find, which means you don't work. And they will try to prevent you from having an internet-based job. That's just the way it is. That's not the answer he's looking for. But so whether he can be a productive citizen in this state, I would hope so, but I would be dubious based on what I know about how they treat people here.
And you are pretty well informed on how people are treated in that particular state.
I am indeed, and I would encourage him to look at that as an option, but be aware that it's not going to be. And we've talked about interstate compact before. It's not going to be a piece of cake to get here. And if he does get here, everything that his MSR conditions are imposed by Illinois come with him, plus whatever our authorities impose on him while they're supervising him, as long as they're reasonably similar to what they impose on people convicted of that type of offense here. So you don't get laxity, you get what your state imposed plus what the receiving state imposes, and it could be horrendous when you combine those two.
I think that totally wraps up everything that we have time to do.
Thank you.
All right. So here's like the quick info. Registrymatters.co is the website. Voicemail is 747-227-4477. Email is registrymatterscast@gmail.com. And we love all of our listeners, but we especially love the people that support us, that make all this possible and fun. Patreon.com/registrymatters. Find us on YouTube, Twitter, all that stuff. Search for us on your podcast app, and you can search for Registry Matters everywhere. Larry, you are an amazing amount of knowledge, and I appreciate all the time that we spend doing this, and I will see you over on the other side for the Patreon Extra.
Thanks a lot, and good night, everyone, and good day, whatever time you're listening to it. Thanks for listening and supporting us.